hope you all revised whatever has happened in the last class. Okay, so we haven't covered much in the last class, but we are trying to understand the basic concepts. One is we try to understand as to what is a constitution. Then we understood the definition of state, probably not the definition of state under the constitution. As we'll proceed, we'll also understand one more definition of state under the constitution, but that is for the purpose of part 3 of the constitution. But yesterday what we understood is the general political science definition of state. Then we understood some of the important features. One is we try to understand what is democracy, what is parliamentary democracy. We also understood the concept of separation of powers and checks and balances. Okay, can anyone tell me what is the very crux of parliamentary democracy? What is the very essence of parliamentary democracy? Accountability of, how there is an accountability of executive to the legislature. Because any government that will be formed in a parliamentary democracy, not only at the time of forming the government, but also continuously, they need to have the majority in the legislative body. That means in India's case, the union government should continuously have majority in which house? In the Lok Sabha. Similarly, if you see the state level, a state government, whichever is formed, they need to have continuously majority in which house? In the legislative assembly of that particular state. Is that clear? So, in fact, for this accountability only, the Constituent Assembly has preferred parliamentary democracy or what is called as presidential democracy. And then we understood the concept of what is called as separation of powers. Can anyone tell me why in India we do not have clear separation of powers? We did understand the concept of separation of powers, but why do we say that there is no clear separation of powers or complete separation of powers? Overlap between the executive and the legislature. But however, we do rely upon the principle of what? Rely upon the principle of checks and balances. What is this principle of checks and balances? How one organ is able to exercise some element of control over the other organ. Therefore, no organ can function arbitrarily. If they try to function arbitrarily, there is another organ which can exercise control over the organs in the state. So that principle is basically what is called as checks and balances. Alright, so with that we'll move to the next topic, that is division of powers. Any doubts from the previous class? Do you have any doubt? No doubts? Clear? Okay. So write down a line as to what is division of powers. Division of powers means an arrangement in the constitution which allows for sharing of powers between national and subnational authorities. Sharing of power between national and subnational authority. Sharing of power between national and subnational authority. In other words, division of powers. Division of powers ensures. Division of power ensures a federal political system. Division of powers ensures a federal political system. In other words, division of powers allows for what? It allows for a federal political system. So, say let us take the Constitution of India. So, this is the Constitution of India. So, many times you might have heard that India is a federal political system. So how many of you heard that India is a federal political system? Or some of you might have heard that India is a quasi-federal political system. It's not a true federal political system. That's a mere criticism. We'll come back to that later. But as of now, we'll have to understand as to what is division of powers. So division of powers means any constitution for that particular matter. It allows for division of powers between what is called as the national and the subnational authority. The national here means at the union level, union, and the state. That means you'll have to understand when I say that there is division of powers between the union and the state authorities, the only thing that you have to understand is the state authorities are not subordinate to the union. The state governments are not subordinate to the union government, but directly the state governments or the state authorities are deriving the powers from where? Deriving the powers from the Constitution of India. So is the union authority. They also derive the powers from the Constitution of India. That means the state authorities are not under the mercy of the union authorities, but rather directly they are deriving the powers from where? From the Constitution. So this arrangement in the Constitution is basically what is called as division of powers. So the Constitution itself gives some element of power to the union. The Constitution itself gives some element of power to the states. So such an arrangement, if it is there, it is what type of political system? It's a federal political system, or in other words, we say the Constitution allows for what is called as division of powers. This is what you'll have to understand. But however, we are not concerned about how much power is given to the union and how much power is given to the states. Whether more power is given to the union or more power is given to the states, that's a secondary concern. Whatever, even if slightest of power is given to the states, but that's directly coming from where? From the Constitution of India, then such a political system allows for what is called as division of powers. So for example, if you take further union authority, I would say there is union executive. So who constitute the union executive? So here we will put the real executives. Yesterday in the yesterday's class, we were trying to understand who are the real executives. Who are the real union executives? The Prime Minister and the Council of Ministers. Though the union executive head is the president, but the real power is in the hands of the Prime Minister, the Council of Ministers, and all those people. And similarly, we have a union legislature. What do you mean by union legislature? And what is that? It is a parliament. So we have seen the union legislature. And similarly, at the state level, you also have what is called a state executive. And you also have the state legislature. So here it is the CM and the Council of Ministers. And what constitute the state legislature? A state legislature. So when you talk of the union legislature, in a union legislature, definitely there are two houses. What are the houses in that? The Lok Sabha and the Rajya Sabha. But the constitution does not necessitate that there have to be two houses in the state legislature. Definitely there has to be one house. Which is the house? State Legislative Assembly. But if a state want, they may have legislative council also. So therefore, have you ever heard of the word what is called as bicameralism? Have you heard of bicameralism? So bicameralism politically means that there has to be two houses. That means in a legislative body there has to be two houses. Bicameralism is mandatory in the union legislature, but bicameralism under the Constitution of India is not mandatory in the state legislature. So in the states there has to be definitely one house. The state legislative assembly has to be there, but there's another house can also be there. That is what is called as legislative council. But not it is mandatory for every state in our country to have what is called as legislative council. If they want, they can have it. We'll understand that process how they can have it later. But can anyone tell me how many states in India presently has got two houses? Not many states. Very good. There are only 6 states as of now which has got two houses. Even that fact is not very important. There are, as of now, only 6 states. All the other states are having only one house. That is only the state legislative assembly. Anyways, the point here is we know that the Constitution of India is there. There is an union authority. There is a state authority. Between below the union authority, you have union executive, you have union legislature, and then at the state level, you have state executive and the state legislature. Now, be it the state executive or be it the state legislature, they're not deriving, they're not at the mercy of the union authorities. They are directly deriving the powers from where? From the Constitution of India. What the chief minister and the council of ministers can do, they are directly deriving the powers from where? From the constitution. As per the constitution, they can function. It is not that the union executive, the prime ministers and the council of ministers can direct the states with regard to what they can do, because they are directly getting the powers from where? From the constitution of India. Similarly, what kind of law can be made by the state legislature? They are also deriving the power directly from where? From the constitution of India. What is the executive actions? What is the power of the Union Council of Ministers? They are directly deriving the powers from the Constitution of India. What kind of laws that can be made by the Parliament? They are directly deriving the powers from where? From the Constitution of India. For example, there's one specific schedule in the Constitution, if you are aware of, which clearly says what is the area on which the Parliament can make laws, what is the area on which the state legislature can make laws, what is the area on which both the Parliament and the state legislature can make laws. As it is given in the Constitution, only in those areas they can make laws. It is not that the Parliament can, at its own whims and fancies, on its own can make laws on different areas. Does anyone know which schedule in the Constitution talks about this? It is the seventh schedule in the Constitution. That's an example of what is called as how there is a division of power. So, for example, if you see the Schedule 7, the Schedule 7 clearly demarcates, clearly divides the powers between the union legislature and what is called a state legislature. Say, for example, there is a law on citizenship. So, if you ask this particular question, how many of you are sure that you are a citizen of India? Anyway, citizenship chapter, I'll discuss all those things. How are you sure that you are a citizen of India? No, you raised your hand that you are a citizen, but I'm asking, how are you sure? So, can anyone tell me? Official documents? What official documents? Aadhaar, initially when it came, Aadhaar is only a proof of residence. It is not that only a citizen may have an Aadhaar card. Although the Supreme Court recently said it may be considered for voting rights and all those things, but any resident in India may have an Aadhaar card. So it is in itself is not a proof of citizenship. Any other explanation that you can give? Yes, by birth. Does it mean that anyone born in India shall be an Indian citizen? So by birth in itself is not a complete criteria. So even a foreigner can give, and they can come and they can give a birth to their child. So will the child be eligible to be an Indian citizen? So any other thing that voter ID card, very good. But I would say it's not that you have voter ID card, so therefore you are a citizen. You are a citizen in the first place, and that's the reason the voter ID was issued to you. So voter ID does not explain that why you are a citizen in the first place. Voter ID is a proof of your citizenship, agreed. But you are a citizen in the first place, and that's why the voter ID was issued to you. Similarly, somebody says that I have a passport. Passport is a proof of a citizenship, but you are a citizen in the first place. That's why the passport was given to you. Therefore, what is the criteria that made you to be a citizen of India? Anyways, we'll discuss that. You can just think about it. Anyways, we'll discuss that in the citizenship chapter. But the point that I'm trying to say is we are all citizens of India by way of a law. The law has provided for certain criteria, and based on the law, if you satisfy that particular criteria, they are all considered to be the citizen of India. But who can make laws with regard to citizenship? Who can provide for that criteria? It is only the power of the parliament, because in the schedule 7 of the constitution, that power is given to whom? That power is given to the parliament and not to the state legislature. Similarly, say for example, on law and order, any law can be made only by the state legislature. The parliament cannot make a law with regard to law and order, because that power has been given to whom? That power has been given to the state legislature. So similarly, on certain areas with regard to defense, with regard to citizenship, with regard to international relations, these are all power which is given to whom? The state parliament. And similarly, law and order, police, agriculture, these are all some of the items which has been given to whom? To the state legislature. So this demarcation, this division is clearly there in the constitution. So such a design in the constitution is what is called as a federal political system. Is it clear to all of you? That means the state authorities are not subordinate to that of the union authorities, but rather directly they derive the powers from whom? Directly they derive the powers from the Constitution of India. So this is basically what is called as a federal political system. But however, as I said, not every federal political system is there is an equal division of powers. We are not concerned whether it is equal or unequal. The moment it is having division of powers, then that political system is what type of political system? Is a federal political system. So therefore, is India a federal political system? Yes, there is a division of powers. But however, there is also something, one more thing that you have to know, that though there is a division of powers, there is an unitary bias. That means though there is division of powers, more power is given to whom? More power is given to the union. So that is a secondary concern. But anyways, there is a division of powers. So write down the next feature. So next characteristic feature or a salient feature about the Indian Constitution is federation with unitary bias. Federation with unitary bias. Federation with unitary bias. So just write down a line on that. It's a type of arrangement. It's a type of arrangement. It's a type of arrangement where though there is a division of powers, it's a type of arrangement where though there is division of powers, the power may not be equally divided. The power may not be equally divided. The power may not be equally divided between the power may not be equally divided between the national and the subnational authority. The power may not be equally divided between the national and the subnational authorities. Between the national and the subnational authorities, or between the union and the states, or between the union and the states. For example, for example, for example, in case of India, for example, in case of India, though there is division of powers, though there is division of powers, though there is division of powers, more powers are given to the union. More powers are given to the union. More powers are given to the union. So between the union and the states in India, who is having the more powers? Union. So definitely there is some power which the constitution is directly giving to the states. But who is having more powers? Union. So we should also know some examples. So where union is having more powers. So for example, I said that in the schedule 7 of the constitution, it is saying on what areas a parliament can make laws and what areas a state legislature can make laws. If you see this, there are 100 subject matters, 100 areas where on which who can make the laws? The parliament can make laws. But you know how many items has been given to the states? Any idea? So 100 items are subject matters. You can say citizenship is one subject matter, defense is another subject matter, international relations is another subject matter. So on and so forth. There are at least 100 areas on which a parliament can make laws, but the state legislature can make laws only on 61 subject matters. So therefore, between the union and the state, who is having more power? It is the parliament. Second example. Today, how many states are there in India? 29 or 28? And how many union territories? 8 or 9 or 7? 28 states and 8 union territories. That is the present political structure. All right. So earlier it is okay. Now you have started preparing for UPSC. You should at least be aware of the developments. How many states and union territories are there? Now, why I'm saying that, it can go for a continuous change. So do you know how many states were there at the commencement of the constitution? How many states and how many union territories at the commencement of the constitution? Let me see that who is able to do it very correctly. 14? 14 states and 6 union territories. Okay, any other answer? 14 states and 6 union territories. How many of you think it is 14 states? And okay, I understand that you're all new to the class, so nothing wrong that if you're not aware of it. If you know that, you can just share it. How many of you think it is 14 states and 6 union territories? Anybody else who has another answer? How many of you do not have any idea? It's okay. You are here to learn only. In fact, at the commencement of the constitution, there was no union territories. At the commencement of the constitution, the classification was only Part A, Part B, Part C, and Part D states. The states are only classified. The territory of India was only classified as what? Part A, Part B, Part C, and Part D states, which will later understand when I go to Part 1 of the constitution, when I deal with union and its territories. Somebody told me an answer of 14 states and 6 union territories. That was only 1956. Only in 1956, the territory of India was reorganized into what is called as 14 states and 6 union territories. But today we are in 2026. That was 14 states and 6 union territories over a period of time was continuously reorganized. And today, how many states and union territories are there? 28 states and 8 union territories. That means, is there a possibility that they can increase the number of states? Is there a possibility they can decrease the number of states? Yes, because we have once 29. In 2019, there were 29 states, and now it has become 28 states. Therefore, in the future, the states can be increased, it can be decreased. But ultimately, it is authority of whom to do all those things. It is only the power of the parliament. If the parliament wants, the parliament can unilaterally destroy the states. Now, it doesn't mean that the parliament is going to destroy the states. It only means that if the parliaments want, the parliament can unilaterally divide the states, increase the states, decrease the states. The states does not have any power to prevent this. Therefore, between the union and the state, who is more powerful with regard to reorganizing the states in our country? It is ultimately the authority of the parliament and not that of the state legislature. So, when you talk of a federal political system, the idea is that there is division of powers. But there is also a concept of what is called as equal division of powers. If you talk of an equal division of powers, that the authority of the center or the union and the states are equally divided. But however, in the Indian constitution, there is no concept of what is called as equal division of powers. Though there is division of powers, the power is divided in favor of whom? In favor of the union. That there is a tilt in favor of what is called as the union. The union is more powerful. So these are all some examples. But as we'll proceed, we'll understand a lot of areas where the union is given more power than that of what is called as the states. Is that clear to you? When I say union, it can be union executive or it can be union legislature. So overall, union is given more power than that of the states. So what are the examples that you have written? One is more items on which the union can make laws. Second, you can write under Article 3 of the Constitution. Under Article 3 of the Constitution, under Article 3 of the Constitution, the Parliament has a power to unilaterally alter the boundaries of the state. Unilaterally alter the boundaries of the states or even destroy the states. Destroy the state doesn't mean that they're attacking the states. It only mean that that state can be no more. They can just merge it with another state. They can create a new state. Anything can be done by the parliament. So, anyways, when I say that though it is a federation, do you understand that how it is a federation with what type of bias? Federation with unitary bias. So, as of now, you should know this. So, as of now, the idea is not that how that is done under Article 3 or how it is done under any of the other. That we'll do when we do Article 2. But right now, I'm just trying to give the features. Okay, so please write down the next thing: integrated and independent judiciary. So, is a concepts. Whenever you have any concepts, please ask me. Although I'll give you time to ask me. At the time, please ask whatever is your doubt. Independent and integrated judiciary. Independent and integrated judiciary. Okay, so there are two keywords that you have to understand. One is independent and integrated judiciary. So, we have seen that there are three important organs in the state. What are the three important organs in the state? The legislature, the executive, and the judiciary. And what is the role of the judiciary? It is to review the actions of the other two organs. Whenever whenever the other organs they do something which is in violation of the constitution, who has the power to declare them to be void or illegal? It is the judiciary. So, to that extent, the judiciary function. So in case of India, if you see the judiciary, we have what is called as an independent and integrated judiciary, or an integrated or independent judiciary, but the appropriate way of saying is more appropriate is independent and integrated judiciary. So first let us try to understand as to what is an independent judiciary. What is an independent judiciary? An independent judiciary is a judiciary which is free from unnecessary pressure from the other two organs of the state. It can function independently. They are not subjected to any restrictions in their functioning by the other organs of the state. That's basically what is called as an independent judiciary. Now, what is the role of the judiciary we have learned? The judiciary is supposed to judicially review. Suppose, let us assume, is it possible that a case can be filed against the government also in the judiciary? See, for a judiciary, be it an ordinary citizen or be it a government, the case is just a case. Can a judiciary give more importance to a case that is filed by the government and not to a case which is filed by a private individual like you and me? It has to see everybody as one party, that's it. And according to the merit in that particular case, it has to pass an order. So that is how the judiciary has to act. But however, suppose let us assume the government has some element of control over the judges. If the judges are under the control of the government, is it possible for the government to pressurize the judges and to pass an order in their favor? Many times it is possible the government may file case against the citizens, or the citizens may file case against the government. So can you give me an example of instances where the citizens may file case against the government and the government may file case against the citizens? There are a number of areas. Say for example, no, I'm not asking a practical example, just a real example, just a hypothetical example. The way. So for example, the citizens may file case against the government for the violation of the fundamental rights because the rights are against the government. And similarly, the state may file cases against citizens, say for example, for violating the law, or say for example, not paying taxes. In this way, a lot of disputes can be there between the citizen and the state. And anyways, who has to resolve all these disputes? The judiciary has to resolve all these disputes. Can the judiciary be in favor of one particular individual? Definitely, a private individual capacity to pressurize the judiciary is not very high. But will it be possible for the state to pressurize, the government to pressurize the judges? It might be the Constituent Assembly was of the opinion, because of their authority and powers that they exercise, there may be indirectly they may put some pressure, but to avoid that, deliberately they wanted to make judiciary as what type of judiciary, to prevent all those things. They wanted to make the judiciary as an independent judiciary. So what is the understanding that you should have? The idea of independent judiciary is that the judiciary should be free from the control of the other two organs of the state, be it legislature or be it executive. They are not constrained by the other two organs of the state in discharging their duties and responsibilities. That's basically what is called as independent judiciary. It doesn't mean that they are completely independent, completely free. They are only free from any unnecessary restriction that will prevent them from discharging their duties and responsibilities. All right. So just write down a line as to what is independent judiciary. Independent judiciary means independent judiciary means the judiciary is able to discharge its duties and responsibilities the judiciary is able to discharge its duties and responsibilities without any unnecessary restrictions from other two organs. Unnecessary restriction or undue pressure from other organs of the state. Unnecessary restriction or undue pressure from other organs of the state. Unnecessary restriction from other organs of the state. Now think how the judiciary is an independent judiciary. So I told that judiciary is an independent judiciary. But what provision in the constitution makes a judiciary an independent judiciary? How do you think that the judges can act without any fear or favor? There has to be some protection for the judges. Unless until that protection is given to the judges, the judiciary cannot become an independent judiciary. Can you just think some examples of some provision or some protection in the constitution that makes the judges really independent in their functioning? The tenure and salary. Even IAS officers, or for that matter, any service that you may get in, you also have a tenure, you also have a salary. But we are not calling as an independent bureaucracy. We are only calling what is called as an independent judiciary. Yes? No, it is not because that they cannot question the judgment. Even if the judgment is not appropriate, anyways, we have a right to go for an appeal against the judgment. It is not that once a judgment is given, it is final. The judgment which is given by the Supreme Court is final. That's the highest court. No? How? Okay, no direct. See, even when you are an administrative authority, let us assume in your administrative capacity, you pass an order. It is not that they can ask you to change it. If they are not liking it, anyways, they can make an appeal to a higher authority. So you also have that freedom in administrative capacity. But how do you think that the judiciary is really independent? Very good. It is exactly with regard to the removal. Not even with regard to the appointment, it is with regard to what is called as a removal. Do you know how many judges has been removed in the history of India? In the last 76 years after the commencement of the constitution, do you know that not even a single judge of a Supreme Court has been removed till this point of time? Not even a judge of a Supreme Court, not only a judge of a Supreme Court, not even judges of any of the high courts in our country has been removed. There were prime ministers who have to resign because there was no confidence. There are many IAS officers who has been removed from the services, IPS officers who've been removed from the services on various charges and all those things. Not even a single judge of a Supreme Court and a judge of High Court has been removed till this point of time. It's not because nobody has done any mistake. It's because the process of the removal is extremely difficult. In fact, the parliament tried removing some of the judges, but they could not achieve that particular majority to remove them. Therefore, the removal process of the judges is extremely difficult, and it has been deliberately made so in the constitution for the reason if the removal of the judges are extremely easy, any government which has got a majority in the legislature, do you know that the government can put the judges in stress if any case of the government is there in front of the judge? But the judge, knowing that he or she cannot be easily removed, so will they enable them? That provision, will it enable the judges to act in an independent manner? So deliberately in the constitution, it has been made extremely difficult. So one example is the removal of judges is extremely difficult. So once appointed, especially the judges of the higher judiciary. I'm talking about the judges of the higher judiciary. So higher judiciary means it includes what type of judges? Higher judiciary means it includes both the Supreme Court and the High Courts. Below the High Courts, it is called as subordinate judiciary. Okay. So the removal of the judges is extremely difficult. So that makes them to function really in an independent manner. So one is yes, independent judiciary, but the judiciary in India is also what is called as an integrated judiciary. What do you mean by integrated judiciary? It is not about being subordinate. In fact, recently, even the former Chief Justice of India has openly said that the district courts, which is basically called as the word that we use is subordinate courts. He said that though we use the word subordinate courts, it should not be viewed that the district court are subordinate to the other courts. So when you talk of hierarchy of judiciary, it is not that they are subordinate. But when you talk of hierarchy of judiciary, sorry, when you talk of integrated judiciary, you should understand that there's only one single hierarchy of judiciary. So if you see the judiciary in our country, how it is placed, there's only one single hierarchy of judiciary. So if you see this particular hierarchy, who is at the apex of the hierarchy? So if you see the hierarchy of the judiciary, who is at the apex of the judiciary? So at the top you have got the Supreme Court, which is the apex court in our country. And then every state you have got what? If not every state, at least every state is coming under the jurisdiction of a particular high court. And then at the bottom you have what? Subordinate judiciary. What I am trying to say is, we are not saying an independent executive, sorry, we are not saying an integrated executive. We are not saying an integrated legislature, but we are using the word integrated judiciary. Now, why we are using the word integrated judiciary, but we are not using the word integrated executive or the integrated legislature? Because when it comes to executive, there is a separate union executive and there is a separate state executive. When you talk of legislature, there's a separate union legislature and there's a separate state legislature. But whereas when it comes to judiciary, There's nothing which is called as a separate judiciary for the union and there is separate judiciary for the states. We all have only one judiciary for the entire country. And what type of judiciary is that? We have what is called as an integrated judiciary. So integrated judiciary means one single hierarchy of judiciary, and this judiciary is perfectly capable enough of trying the cases related to the central laws as well as to the state laws. That means whether can we file a case related to a parliamentary law in any of these courts? Yes. Can the same judiciary can also try cases related to the state laws? Yes. So this is one single integrated judiciary. Is it clear to all of you? On the contrary, if you see in some of the countries like USA, there is no integrated judiciary. There is a parallel judiciary. When I say parallel judiciary, there is one federal judiciary. That is, you can say that there is one union judiciary, and for every state there is a state judiciary. And that federal judiciary will take up cases only which is related to the federal laws, and every state judiciary will take up cases related to the state laws. And that type of judiciary is not an integrated judiciary. So the Indian constitution is a little unique. So if you go to the division of powers, what is the meaning that we had with regard to division of powers? Division of powers means demarcation of powers between the union and the state authorities, that is national and the subnational authorities, or union and the state authorities, where I clearly said that the division is with regard to only what is called as the legislature and the executives. It is not about the judiciary, because with regard to judiciary we have what type of judiciary? We have one single system of integrated judiciary. Therefore, suppose let us assume a state is making a law. Can that law can also be challenged in the Supreme Court? Can that law be tried in the Supreme Court? Suppose if it is a union law, can that law also be challenged in the high courts? Yes. It is only one single system of judiciary. So in certain cases you can directly go to the high court, in certain cases you can directly go to the Supreme Court. It does not matter whether it is a law by parliament or whether it is a law by the state legislature. We have got only one single hierarchy of judiciary. That's basically what is called as integrated judiciary. So just write down a line as to what is integrated judiciary. So integrated judiciary means one single hierarchy of judiciary. Integrated judiciary means one single hierarchy of judiciary. One single hierarchy of judiciary. One single hierarchy of judiciary for both center and the states. For both union and the states. So one single hierarchy of judiciary for both union and the states. For both union and the states. There is no separate hierarchy of judiciary. There is no separate hierarchy of judiciary for the state. For the state. For the state. As in some of the, as it is there in some of the federal constitutions. As it is there in some of the federal constitutions. As it is there in some of the federal constitutions. So this is what you'll have to understand as to what do you mean by what is called as an independent and integrated judiciary. So please go through all these concepts. If you have any doubts, please ask me before we move forward, because understanding these concepts are very, very important. All right. So anyways, write down the next topic and try to go through all these things. So write down the next topic, that is written constitution. So written constitution is also an important feature of the Indian constitution. Okay, just please take a couple of minutes, go through all the things that you have learned. You please try to go through it once. Any doubts in understanding these concepts, please ask me. Yes, that is a general term, because the subnational authorities as to how they define it in their constitution can vary from country to country. So normally it means an institution like state. Yes, it yes, yes, any code. So it depends upon which law based on which you are challenging it. So suppose you are challenging the action of the union government under that law, you can go to the district court if the law allows for it. If you want to challenge the action of a state government also, you can go to the district court. Okay, so depending upon whose action, accordingly which law you can challenge it. So there's no separate hierarchy of courts for the union law. There's no separate hierarchy of courts for the state law. Suppose if it is a violation of a fundamental right against the union government, then you can directly go to the Supreme Court also. Against the state government also, you can directly go to the Supreme Court, provided it is a violation of your fundamental right. But not directly in all the cases you will be able to go to the Supreme Court. So that is something that you later understand. But for time being, you understand the concept of integrated judiciary means that there's no separate hierarchy of judiciary to challenge the central action and to challenge what is called as a state action. So it is only one integrated, one single hierarchy of judiciary. All right. Yes, any other doubt? Yes, when I say that it is a federation with unitary bias, in other words, is nothing but it's a quasi-federal thing. Because when you say it is a federation or a true federation is something there is an equal division of powers or more powers to the states. But if a federation is giving more powers to the union, then you can call that as a federation with unitary bias. Or some of the political analysts have also called that to be what is called as quasi-federal. That means it's not a true federation. All right. All right. So please write down the next thing, that is a written constitution. So how many of you agree that the Indian constitution is a written constitution? Yes. In fact, the Indian constitution is the lengthiest known written constitution in the world. But can anyone tell me why it is called as a written constitution, or in other words, what is the difference between a written and an unwritten constitution? We are saying that the Indian constitution is a written constitution for the reason there are some constitution which is also called as unwritten constitution. So what is the exact difference between a written and an unwritten constitution? Hmm. Okay. In UK, sorry, the unwritten constitution is based on conventions. So can you give me an example of an unwritten constitution which is based on convention in UK? So when you say that the UK constitution is unwritten constitution, that is true. But the UK constitution is not only based on convention. It's not purely based on convention. In UK also there are a number of legal documents which is written down based on which the country is governed. So therefore to say an unwritten constitution is purely based on convention is not a right thing. It may include some convention. That's okay. But what is the exact difference between a written and unwritten constitution? Consolidation. So yes, can you further elaborate what you understand by consolidation if you're comfortable? Okay, so very good. So only small correction to that. When you say a written constitution is something that there's only one source for the entire constitution. That whatever is what is called as the text or the document of the document which is considered to be the constitution. Everything is put together in one single place. But not necessarily, try to understand, when I use one single place, not necessarily that constitution, the country should have only one constitution. It can be one document, two document, three document, that does not matter. But majorly, most of the 10 constitution, they have only one single document as a constitution. So how many documents we have in India as a constitution? And today, if you see the constitution of India, we have seen that how many articles are there, how many parts are there, how many schedules are there. Can anyone recollect how many articles, parts, and schedules we had? So presently, we have got 471 articles, we have got 12 schedules, and we have 25 parts. That's what is making the constitution of India. Now, apart from that, none of the other things is the constitution of India. So there's only this is what is the constitution of India. But apart from this, do we have other laws in our country? But they are not the constitution of India. What is the constitution of India? Whatever is written down in the constitution. So any written constitution, if you take, there will be one document or more than one document as well. Not necessarily one single document. But apart from that, even if they have the other laws, They are not considered to be the constitution. That means the source of a written constitution is very clear. The source is always that whatever is written down in the constitution. Only that makes what is called as a written constitution. But whereas on the contrary, in an unwritten constitution, this is the biggest misunderstanding students have, that a written constitution is codified and an unwritten constitution is not codified. An unwritten constitution is not that it is not codified. An unwritten constitution is also codified. But what is the difference between a written and an unwritten constitution? In a written constitution, whatever is codified in the text of the constitution is only the source for the constitution. Other things are not the constitution. But in an unwritten constitution, a lot of things can be codified. There also it is codified. But there is nothing explicitly what is called as a particular constitution. So for example, in UK, there can be lot of ordinary laws which is made by their parliament. All the laws that is passed by their parliament is also part of their constitution. The convention that is exist in UK, that is also part of their constitution. The judgments that is passed by the judiciary, that is also part of their constitution. Therefore, it is not codified. The source of the constitution is not coming from one particular place or one particular document, but the source is what? The ordinary laws also, the source is convention also, the source is judgment also. So when you have such a constitution, such type of constitution is what type of constitution? That is an unwritten constitution. It may also be largely codified, except for the convention, which may not be codified. The laws, the ordinary laws, the judgments, they are all codified, they are all written down. But the source of the constitution is much wider in an unwritten constitution, whereas the source of a written constitution is just whatever is found in the text of the constitution. Is that clear to all of you? That's a basic difference between a written and an unwritten constitution. But in anyways, in India, what type of constitution we have? We have a written constitution. That means the source of the constitution is India is what is the text that is codified in the document of the constitution. Nothing more than that. Is that clear to all of you? We may follow some convention, but that convention cannot be seen as the constitution of India. Whatever is written down is what is called as the constitution. So that is basically the difference between a written and an unwritten constitution. Just write down a line as to what is a written constitution. In a written constitution, in a written constitution, in a written constitution, everything is codified. Everything is codified into a single document. Everything is codified into a single document. When I say single document, that is only most likely, not necessarily only into a single document. Codified into a single document. And the source of the constitution is very clear. And the source of the constitution is very clear. That is only the written text in the constitution. That is only the written text in the constitution. That is only the written text in the constitution. On the contrary, you can write on the contrary, in an unwritten constitution, on the contrary, in an unwritten constitution, the source of the constitution on the contrary, in an unwritten constitution, the source of the constitution may include ordinary laws. The source of the constitution may include ordinary laws, comma, conventional practices, comma, judicial pronouncements, etc. So they can include certain other things also. But in a written constitution, what is considered to be the source of the constitution? Whatever is a text in the constitution, most likely one single document. So that's the difference between a written and an unwritten constitution. But do not have any misunderstanding that a written constitution is codified and unwritten constitution is not codified. An unwritten constitution can also be codified, but it is only about what we are seeing is the source. The source is much wider in an unwritten constitution. The source is limited to the text in the constitution. That's basically the primary difference. So in India, we strictly follow what is called as a written constitution. So write down the next thing, that is drawn from multiple sources. So how many of you heard that one of the criticism to the constitution of India is also it is considered to be a borrowed constitution? In fact, it was one of the criticism to the drafting committee in the parliament. Sorry, drafting committee in the Constituent Assembly. So in the Constituent Assembly, there was one specific committee whose responsibility is to draft the Constitution of India. To have a Constitution of India is a responsibility of the entire Constituent Assembly. They will finally approve. But a specific expert members were given the responsibility to first draft it. And thereupon the draft will be discussed, can be made changed, and then finally it was adopted by the Constituent Assembly. So one of the basic criticism of the work of the drafting committee is that it was a what is called as a borrowed constitution. In fact, to this criticism only Dr. B.R. Ambedkar said nobody can have a patent right over the various provisions of the constitution. If some constitution is having some provisions, nobody owns a patent right for those provisions, because rights, liberties, everybody has to have it. Somebody already had a constitution, they provide rights to their people. They cannot say that it's only in my country, only my people shall have the rights, the people in the other country shall not have the rights. So many countries already has got good provisions, so therefore we are taking those provisions, nothing wrong in that. But how many also know that the Indian constitution is not completely a borrowed constitution? In fact, a bulk of the Indian constitution came from where, do you know? It came from the government of India Act 1935, which already was in place, based on which the British India was administered. But anyways, a lot of provisions has been borrowed from the other constitutions as well. So you can just make a note of few things. So for example, you can write down the parliamentary system that we have today is largely taken from the Constitution of United Kingdom. So drawn from multiple sources. So to name a few, you can write down, not a very important topic, just you should have a fair idea as to some of the provisions. Say for example, the parliamentary system that we have today or we follow today, it's largely from UK. Say for example, the fundamental rights, or say let us assume the system of judicial review is largely from the Constitution of USA. Um, Say let us assume the ideas like liberty, fraternity, this is from the Constitution of France. The idea of concurrent list, the kind of concurrent list, the idea of concurrent list. Say for example, in the Schedule 7, when I was discussing, I told there are certain areas only where the parliament can make laws, certain subject matters. There are certain subject matters on which only the state legislature can make laws. Wherever the parliament can make laws, which is called as a union list. Whereas the state legislature can make laws, that is called as a state list. But apart from that, the Schedule 7 also has something which is called as a concurrent list. That means those items on which both the parliament and the state legislature can make laws. So this we have taken from the Constitution of Australia. Largely the kind of federal political system, that we have, the model of division of powers that we have is taken from Canada. Some of our emergency provisions that we have, so there's also some emergency provisions under the constitution, so that we have taken it from Germany. So these are all few examples to say that we have largely borrowed some of the important provisions from the other constitutions across the world. But you can also write a small note, even today the bulk of the Indian constitution, so on top of all those things, but the bulk of the Indian constitution has been borrowed from the government of India Act 1935. So the Government of India Act 1935. So don't worry about this Government of India Act 1935. There's a topic in your syllabus. In fact, the very first topic in your main syllabus. Have you gone through a main syllabus which talks about what is called as historical background or historical underpinnings and evolution? I will also discuss that. We'll discuss for say around 3 to 4 hours the entire topic. So there I'll discuss about this Government of India Act 1935 and all those things. Does anyone know what is this historical underpinnings? When did the Constitution of India came into force? 26th January 1950. Most of the provisions came into force only on 26th January 1950. When India became independent? On 15th August 1947, India became independent. We had a constitution after a couple of years. Okay. That means even after the independence, India was still governed. India was still governed only by the Government of India Act 1935 because immediately after independence, we did not have a constitution. That was the role of the Constituent Assembly to develop its own constitution. So even after independence, India was still governed by which act? Government of India Act 1935. Therefore, this Government of India Act 1935 had a huge influence on the Constituent Assembly. And a lot of provisions of this Government of India Act 1935 was now made part of the Constitution of India. But who made this Government of India Act 1935? Who made this Government of India Act 1935? It was a law passed by the British Parliament to govern British India. But this is not the only law that is passed by the British Parliament to govern British India. Do you know what is the first law that was passed by the British Parliament to govern British India? Which is the first act that they have passed? Which regulating act? You are correct. Very good. Regulating Act of 1773. That means starting 1773, gradual constitutional reforms were brought in by the Britishers to govern British India. So how it has developed over a period of time is basically what is called as historical underpinning or evolution. So we'll also try to understand. Probably you may expect one question in your mains from that particular area. Not a very important area. If you see the last 10, 12 years, there's only one question has been come from that particular area. But you should have a fair understanding of that particular area as well. So once I cover all these salient features and all those things, I'll also go to that historical underpinning. So there you will have a fair idea of all those things. So as of now, this is what you'll have to understand as to why the Constitution of India is what is called as a constitution which is drawn from multiple sources. Write down the next thing, the next feature of the Indian Constitution, it is rigid and flexible. Rigid and flexible. Just write down a line when I say rigid and flexible. So before I explain why the Indian Constitution is seen as a rigid and flexible constitution, do you know that one of the feature again that of the Indian Constitution is that the Indian Constitution is also called as a living document or an organic document. What does it mean? The Indian Constitution, when we say that the Constitution of India is a living document or an organic document, what is the idea that it reflects? That means it can go for a change. It's not a very static document. It has to evolve over a period of time. It has to change over a period of time. It can be altered, modified, amended. That is what it means. So, does it make any sense for the Constituent Assembly to design a constitution in such a way and where they wanted that constitution to continuously evolve, continuously change, altered? Does it make sense? Why a static constitution is not something which is very good? Because a static document may not reflect what is required by the present generation. Because the constitution was developed 75 years back and we have made rapid changes over a period of time. We are not saying that you change everything, but wherever there's a change required, it should go for a change or not, to accustom and to change. So therefore, the Constituent Assembly, it was their vision that the constitution should not be a static document, it has to change. So basically, most of the constitution across the world is a living document. It's an organic document. It can go for a change. But however, to what extent they can go for a change, at what pace they can go for a change, how easy is it to change the constitution may differ from constitution to constitution. So when I say it's a rigid constitution may go for a change, but changing that is not easy relatively. Or making alterations, making changes in the constitution is relatively not easy. But when I say it's a flexible constitution, making changes in that particular constitution is relatively easy. But when I say rigid as well as flexible, that means it's a combination of both the types of constitution. That means some provision can be easily altered, some provision is difficult to alter. So one of the unique feature of the Indian constitution, it is a combination of both rigidity as well as flexibility. So just write down a line. So what is the topic that you have written? Rigidity and flexibility. So please write down. Rigidity reflects the idea. Rigidity reflects the idea. Rigidity reflects the idea that making modifications or alteration to a constitution is relatively difficult. Is relatively difficult. Relatively difficult. Flexibility. Write on the next point. Flexibility reflects the idea. Flexibility reflects the idea. Making alterations or modifications to a constitution is relatively easy. Flexibility reflects the idea that making modifications or alteration to a constitution is relatively easy. Write down one more line. Most constitution across the world is either rigid or flexible. Most constitution across the world is either rigid or flexible. That means either they fall under the category of what? Rigid, or they fall under the category of flexible. For example, USA is a rigid constitution, extremely difficult to amend. They can be amended, extremely difficult. On the contrary, if you see the constitution of United Kingdom, extremely flexible. So write down the next line. One of the unique feature of the Indian constitution is it is a blend of rigidity and flexibility. It is a blend of rigidity and flexibility. It's a blend of rigidity and flexibility, as some of the provisions in the Indian constitution can be altered by a simple procedure, as some of the provisions in the Indian constitution can be altered by a simple procedure. When I say simple procedure, within that you write in bracket. So when I say simple procedure, after writing simple procedure, within bracket you write down simple majority. I'll explain this later very soon, but for time being you write down by a simple procedure, that is simple majority. Some of the provisions in the constitution can be altered by a simple majority, but most of the provisions can be amended by a relatively difficult procedure, which requires special majority. Which requires special majority in the parliament. So for time being, you just understand that simple procedure means relatively a simple majority is required. That means less number of people in the parliament, they itself can support and they can make the changes. But most of the provisions can be amended by what? By a relatively difficult procedure which requires a special majority. It is a higher majority that is required in the parliament. So how to calculate that majority, we'll see it in the coming classes. But for time being, some of the provisions can be altered by simple majority. Some of the provisions requires only a higher majority amendment. So this is what you'll have to understand. So the Constitution of India is both a combination of both rigidity as well as what is called as flexibility. Come to the next thing, that is fundamental rights. Okay, so before I go to fundamental rights, can anyone tell me the concept of what is rights? What do you mean by the word rights? So do we have any other right apart from the fundamental right? So we'll see those different types of rights, but what do you understand by rights in the first place? An obligation of the, okay, very good. So to put it in a very simple way, it is a legal claim or an entitlement. It's a claim or an entitlement which can be legally enforced. That's basically what is called as a right. So what is the simplest way of defining right? Right basically means it's a legal claim or an entitlement. So whenever I say the word legal claim or an entitlement, it becomes important because you legally claim that you are legally entitled. Therefore, the violation of that can be what? The violation of that can be enforced in a court of law. So basically, right is a legal claim or an entitlement, a violation of which can be enforced in a court of law. So can you give me examples of your rights? It's a legal claim or an entitlement. So can you give me an example of that? Right to, right to safe travel. Okay, so any other explicit thing, easier thing, because you are indirectly bringing under the Motor Vehicle Act. But let us talk about something which is direct. Very good. There are a lot of fundamental rights. Right to life is there. Right to liberty is there. Right to freedom of speech and expression is there. Right to equality is there. Apart from that, can you say any other rights? Very good. Right to information is there under the Right to Information Act. Any other right? Very good. Right to property is there under Article 300A of the Constitution. So therefore, very good. So now different types of rights has come. So right is basically what? Right is basically a legal claim or an entitlement. But however, depending upon where the right comes from, what is the source of that particular right, you can also classify. Now, one thing that is common about all the rights is that all the rights are a legal claim or an entitlement, a violation of which can be enforced in a court of law. But depending upon where they come from, further you can classify these things, or I would say, depending upon the source of these rights, they can be further be classified into the following categories. So, how you can classify the rights? So, probably rights, depending upon their source, they can further be classified into the following types. So, for example, I would say put one of the highest degree of rights is what is called as a fundamental rights. Where do the fundamental rights come from? Yes, it does come from the Constitution, no doubt. But within the Constitution, a Constitution may provide a lot of rights, but not all the rights that is given in the Constitution is a fundamental right. So it does come from the Constitution, but specifically in the Constitution, where does it come from? Part 3 of the Constitution. So anything that is flowing from the Part 3 of the Constitution, not in other places. Anything that is flowing from the Part 3 of the Constitution is what is called as fundamental rights. Is it clear to all of you? So apart from that, if there is any other right, even in the Constitution, that may not enjoy the status of what is called as a fundamental right. Though it comes largely from the Constitution, but specifically where in the Constitution it comes from? It comes from Part 3 of the Constitution. Okay, now the second type of right I would classify as what is called as constitutional rights. So constitutional rights means where does it come from? From the Constitution, but because already we have excluded Part 3. So basically the general reference when I use the word constitutional right, it is coming from the Constitution but outside Part 3 of the Constitution. Because anyways, if it is coming from the Part 3 of the Constitution, I does not merely call it as a constitutional right. I call it as what type of right? I call it as a fundamental right. So therefore, constitutional right basically means some right in the Constitution, but comes from where? that is outside part 3 of the constitution. So do not ask me, sir, this is also a constitutional right. Yes, but the most appropriate way of saying that is what? Most appropriate way is fundamental right, because it is titled as fundamental right in part 3 of the constitution. So when I say constitutional right, it is also coming from the constitution but excluding the fundamental rights. So what are such rights? Can you give me an example of constitutional rights? Very good example. The one example is right to property, which is under article 300A. Now anyways, 300A is not there in the part 3 of the constitution. It is outside part 3 of the constitution. How many of you know right to property was initially a fundamental right? When in the original constitution, there's something which is called as right to property, which was initially a fundamental right, but today it no longer exercises and enjoy the status of a fundamental right. This right to property has been taken out of part 3. The constitution was amended. Does anyone know by which amendment this right to property was taken out? By the 44th Constitutional Amendment Act in 1978. It's not the first Constitutional Amendment Act, although they made some changes in the part 3 of the Constitution. But the right to property, or Article 31, which provided for right to property, was taken out of part 3 of the Constitution and it is placed under Article 300A by the 44th Constitutional Amendment Act. Anyways, we'll learn that at a later stage, but as of now, try to understand as to what is a constitutional right. And similarly, say for example, under Article 326, we have what is called as universal adult suffrage, or your right to vote. That is also coming from the constitution. That is right to vote, universal adult suffrage. So these are all examples of what? These are all examples of constitutional rights. Therefore, basically, we distinguish them based on the sources. Okay, this is in constitution, but specifically where in the constitution? Part 3. This is in the constitution, but specifically where in the constitution? Outside part 3. And then there are also certain rights, which is also called as legal rights, or they are also called as statutory rights. What do you understand by legal rights or statutory rights? What is the source of these rights? The source of these rights are flowing from the ordinary laws of the land. They are not flowing from the Constitution of India. They are not coming from the part 3 of the Constitution. Not necessarily only from the law of the parliament. It can be from the law of the state legislature also. But they are flowing from what? They are flowing from the ordinary laws of the land. Say for example, your right to information, RTI, which is coming from what is called as the RTI Act 2005. Say for example, your right to consumer redressal, which is coming from the Consumer Redressal Act. Right to education is today a fundamental right, which is coming from Article 21A itself. Okay, so right to free and compulsory education has become a fundamental right post the 86th Constitutional Amendment Act in 2002. So right to consumer redressal, right to information, your right to file an FIR under the BNSS. So these are all examples of what is called as legal rights, which comes from the ordinary laws of the land. But however, what is common in all the three categories of rights? Now try to understand what is common in all the three categories of rights. What is common is whenever your right is violated, the source is not important. But in all the cases, when the right is violated, you have the right to enforce it in a court of law. So where you can go and seek a remedy in all these cases. You can enforce it in a court of law. That means you can go to the judiciary. But what really makes a difference between these two, all the three rights, is that of all the three rights, the highest priority is given to which type of right? Fundamental rights. Therefore, when our fundamental right is violated, we do not have to go through the ordinary hierarchy of courts, where we can directly go and file a case if we want. We can go to the Supreme Court directly, or if the individual wants, he can go to the High Court also directly. But except for the fundamental rights, in these two cases, they have to follow the ordinary hierarchy of courts. They cannot directly knock the Supreme Court, because it is seen in such a way by the Constituent Assembly among all the three types of rights, which is very fundamental for an individual. The fundamental rights are very important. So when it is violated, they need to get an immediate remedy. Therefore, where they can go? They can directly go to the Supreme Court. In all other cases also, you'll get the remedy. But you cannot directly knock the doors of the Supreme Court. You'll have to follow what? You'll have to follow the ordinary hierarchy of courts. But anyways, what is common in all the three types of rights? That they can seek a remedy. But where they can seek a remedy depends upon the violation of the rights. Is that clear to all of you? So wherever we use the word rights, rights are basically claims and entitlements. Rights basically gives us the legal protection to move to the courts when our rights are violated. But however, depending upon the right, we may approach the courts. Fundamental right, we can directly move to the Supreme Court, but a constitutional right or a mere statutory right. Statutory here means it is flowing from a statute. The laws, ordinary laws, are basically what is called as a statute. So you can go to the court, but you'll have to follow the ordinary hierarchy of courts. Is that clear to all of you? So that's what basically you'll have to understand as to what is rights. So if you talk of fundamental rights, I'll just come back to your question. Okay, so just hold on. So if you talk of fundamental rights, so fundamental rights are those rights, in the opinion of the Constituent Assembly, they are very fundamental for the human survival. So unless and until these rights are there, the human being will not be able to have a survival. But survival merely doesn't mean it is an life or an animal existence. Survival means they will not be able to have a dignified human survival. So such rights are basically what is called as a fundamental rights. And where these fundamental rights are there, it is there in the part 3 of the Constitution. So just write down a few lines on fundamental rights. These are rights. These are rights in the opinion of the Constituent Assembly. These are rights in the opinion of the Constituent Assembly. The opinion of the Constituent Assembly are very essential. Are very essential. These are rights in the opinion of the Constituent Assembly which are very essential to provide for a dignified human survival. To provide for a dignified human survival. Write down further. The original Constitution. The original Constitution provided for 7 themes of fundamental rights. I'm not saying 7 fundamental rights, 7 themes of fundamental rights. So write down one by one 7 themes of fundamental rights. 1. Right to equality. Right to equality. Within bracket you can write Article 14 to Article 18. Seven themes of fundamental right, Article 14 to Article 18. Then write down right to freedom. Second theme is right to freedom. Article 19 to Article 22. Right to freedom, Article 19 to Article 22. Right against exploitation. Right against exploitation. Right against exploitation, Article 23 and Article 24. Right against exploitation, Article 23 and Article 24. Right to freedom of religion. Right to freedom of religion, Article 25 to Article 28. Right to freedom of religion, Article 25 to Article 28. Cultural and educational rights of minorities. Next thing, cultural and educational rights of minorities. Cultural and educational rights of minorities. Article 29 and Article 30. Right on next thing, right to property, Article 31. Right to property, Article 31. Right on next theme, right to constitutional remedies, Article 32. Right to constitutional remedies under Article 32. Right to constitutional remedies under Article 32. So originally there were 7 themes of fundamental rights. So just write down a note. Presently there are only 6 themes of fundamental rights. So presently how many themes of fundamental rights are there? Only 6 themes of fundamental rights. The right to property has been repealed. Sorry, the right to property has been removed. The right to property has been removed. The right to property has been removed from part 3 of the Constitution and it is placed under Article 300A. So the right to property has been removed from part 3 of the constitution. That is article 31 is taken out of part 3 and it is placed under which article presently? Article 300A. So therefore, please listen to me. So therefore, even today do we have right to property? Yes. But the right to property no longer enjoys the status of what type of right? Fundamental right. It has become a constitutional right, which is outside part 3 of the constitution. Is that clear to all of you? So this is what basically you'll have to understand with regard to the fundamental right. Anyways, as we'll go to the part 3 of the constitution in detail, we'll try to understand about each and every fundamental right. But this is a primary idea that you should have. Yes. What is your doubt? Did you raise your hand? Acha. So okay, I thought you were raising your hand. Alright. So please come to the next thing, that is fundamental duties. Fundamental duties. So just write down a line with regard to fundamental duties. The fundamental duties were inserted. The fundamental duties were inserted by the 42nd Constitutional Amendment Act 1976. By the 42nd Constitutional Amendment Act 1976. On the recommendation of Swaran Singh Committee. On the recommendation of Swaran Singh Committee under Part 4A of the Constitution. Under Part 4A of the Constitution. That means from the first line, what is the understanding you should have? The fundamental duties were not part of the original Constitution. So when the fundamental duties were brought in, the fundamental duties were brought in by the 42nd Constitutional Amendment Act in 1976 under Part 4A. Write down a line as to what is fundamental duty. Fundamental duties or set of moral obligations to the citizens or set of moral obligations for the citizens to perform certain duties towards the state. Fundamental duties are set of moral obligations to perform certain duties towards the state. So here the key word is moral obligation. So what do you understand by the word moral obligation when I say it is a set of moral obligation? Okay, so even before I go to that, so how many duties are there presently in the constitution? Any idea? 11 or 10? So presently there are 11 duties. Can anybody name any of the duties, say for example, out of those 11 duties? Right to? Very good. So right to respect the national symbols, like say let us assume the institutions and the symbols, and also to respect the ideals that has propelled towards the freedom and all those things. Any other fundamental duty? Not right to protect, duty to protect the environment. Okay, any other duty? Okay, so it is also the duty to have scientific temper, then duty to defend the nation when upon called to do so, uh, duty to not to engage in activities which is derogatory of the dignity of women, duty to promote what is called as fraternity in the society or promote a feeling of common brotherhood. So in this way, a lot of duties are there. But you have to understand all these duties put only a moral obligation upon the citizens. And duties are only to the citizens, not to the aliens. It does put moral obligation upon whom? Moral obligation only upon the citizens. So what does it mean? Moral obligation upon the citizens mean. So when I say it is your moral obligation, so what does it mean by moral obligation? Why the word moral obligation becomes very, very important? Huh? Bound to do or not bound to do? Bound to do or not bound to do? So how many of you think moral obligation means it's a legal obligation? So moral obligation means, as it says, that yes, you are supposed to do as a citizen morally, but if you are not still performing it, the state cannot punish you for that. It cannot be enforced in a court of law. It's only your moral duty. Morally, you may feel guilty. Legally, you are not guilty for not performing any of these duties. That means if any of the citizens not performing any of the duty, can the state punish them for not performing it? The state cannot punish it. So that is the importance of the word moral obligation. Is it clear to all of you? So write down one more line on that. The word moral obligation implies that failure to perform any of the duty by the citizens cannot be legally enforced in a court of law. Failure to perform any of the duties cannot be legally enforced in a court of law. Originally, write down originally. So failure to perform any of the duties cannot be legally enforced in a court of law. Originally, there were 10 duties inserted by the 42nd Constitutional Amendment Act. Originally, there were 10 duties which were inserted by the 42nd Constitutional Amendment Act, but presently there are 11 duties. Originally, there were 10 duties which were inserted by the 42nd Constitutional Amendment Act 1976. So, for the expression Constitutional Amendment Act, you can use this Constitutional Amendment Act. So, for your own reference, it's a Constitutional Amendment Act. So, originally there were 10 duties which are inserted by the 42nd Constitutional Amendment Act. So, presently there are 11 duties. The last one was added by the 86th Constitutional Amendment Act 2002. These are all some facts. Sometimes UPSC can ask. The last one, that is the 11th duty, was added by the 86th Constitutional Amendment Act 2002. Write down the next thing, that is directive principles of state policy. DPSP means directive principles of state policy. Write down some facts before I explain the concept. Shall we move to the next concept, directive principles of state policy? Okay. The directive principles of state policy are contained in Part 4 of the Constitution. The directive principles of state policy are contained in Part 4 of the Constitution, from Article 36 to Article 51. From Article 36 to Article 51. The directive principles are nothing but contained in Part 4 of the Constitution, from Article 36 to Article 51. The directive principles are nothing but a set of moral obligation upon the state. The directive principles are nothing but a set of moral obligation upon the state. To perform the directive principles are nothing but a set of moral obligation upon the state to implement moral obligations upon the state to implement the directives given in the Constitution, for the welfare of the citizens. So here also the key word is what? The key word is moral obligation. That means the basic difference between fundamental duties and directive principles of state policy is, in case of fundamental duty, it is a moral obligation of whom? Citizen. But whereas in case of DPSP, it's a moral obligation upon whom? State, to implement these directives for the welfare of the citizens. But in both the cases, that if they're not performing, there the citizen not performing the duty, here the state is not implementing these directives, in both the cases it is not enforceable in a court of law. Therefore write down, because it's a moral obligation, because it's a moral obligation, if the state is not implementing any of the implementing any of the directives, if the state is not implementing any of the directives, the citizens cannot enforce it in a court of law. The citizens cannot enforce it in a court of law. This is very, very important. Just this understanding itself has been the focus of the UPSC in various prelims examination in many years. That you should know, basically the citizens cannot enforce it in a court of law. The citizens cannot enforce it in a court of law. So basically, in one single word, you should know that the directive principles of state policy is non-justiciable in nature. So the DPSP is non-justiciable in nature. Non-justiciable means cannot be enforced in a court of law. So is the fundamental duties. It is non-justiciable in nature. If the citizens are not performing it, it cannot be enforced in a court of law. Is that clear to all of you? So this non-justiciable itself is a very, very important concept. Now, I said that the directive principles of state policy is non-justiciable in nature. In fact, this provision was subject to a lot of criticism in the Constituent Assembly, because the way that they have designed the directive principles of state policy, it is a moral obligation upon whom? Moral obligation upon the state, but performing that would lead to the welfare of the people. But however, it is not obligatory for the state to do that. It is only a moral obligation. It is not mandatory. Legally, it is not mandatory. Therefore, some of the members in the Constituent Assembly said, no, no, it has to be made legally obligatory, because it will lead to what? It will lead to the welfare of the people. So when you put it as a moral obligation for the government, whether to do it or not to do it, will it affect the welfare of the people if they're not doing it? If the government is not doing it, it will affect the welfare of the people. If the government is doing it, it will benefit the people. So therefore, is it better to make it a moral obligation or a legal obligation? It is better to make it as a legal obligation. That's the opinion of some of the members in the Constituent Assembly. But Dr. B.R. Ambedkar said there is no need to make it as a legal obligation, for the reason, first of all, if you read these directives are very idealistic in nature. That means if these directives are implemented, it would be like an utopian state. That means it's a model state. Practically implementing these things, even for the government, is not possible, because the directives are idealistic in nature, but the state does not have the resource to implement them. Therefore, if you make it an obligation, a legal obligation, then it will lead to a lot of cases and all those things. Therefore, we leave it to the state. As and when they have the resources, they will implement those things. That is one reason. But at the same time, Dr. B.R. Ambedkar said, though it is a what type of obligation? Only a moral obligation. No government can take it for granted. Why no government can take it for granted? By constitutional design, any government has to face elections every 5 years. If the government is not implementing these directives, not taking care of the welfare of the people, anyways, the people will remove this particular government out of power. So, in a democracy, if they want to retain power, they have to anyways give importance to these directives, and they have to implement these directives. Then only people will keep that particular government. Otherwise, the people will change the government. Therefore, this in itself is sufficient enough for any government to give due attention to what? Due attention to implementing these directive principles. Therefore, by saying all these reasons, it was the Constituent Assembly largely convinced that the DPSP shall continue to be what type of obligation? Shall continue to be a moral obligation. Is that clear? So this is what you should know about the directive principles of state policy. Yes. Hmm. Enforcing it. Say for example, let us assume Article 39B in the directive principles of state policy is talking about what? It's talking about that the state shall provide for what is called as Article 39B and Article 39C. If you see in the DPSP, there are two important articles. So combinedly, both are allowing for what is called as prevention of concentration of wealth and redistribution of material resources in the society. That means, as far as possible, what the state has to do, the state has to try to prevent the concentration of wealth in the hands of few people, and then not only prevent the concentration of wealth, it also distribute the wealth in the society. This is their moral obligation. But if the state is doing nothing, no citizens can file a case and ask the state to implement this. That is not possible. So they cannot enforce it in a court of law, means they cannot enforce these directives in a court of law. They cannot ask the state to do this definitely, because it's a what type of obligation to the state? It is only a moral obligation. Say, for example, Article 44 of the Constitution. How many of you are aware of Article 44? What is Article 44? Uniform Civil Code. But as of now, we do not have a uniform civil code. I mean, at least at the national level, we do not have a uniform civil code. Only very few states, one or two states, we have uniform civil code in Goa, and I think Uttarakhand has recently brought in a uniform civil code. Some of the other states are on the verge of probably bringing it. I don't think they do have a law. Probably they are now contemplating of introducing some bill and all those things. Functionally, I would say it is only in the state of Goa. Uttarakhand recently they brought in a law. But however, it is for the state to provide for what is called as an uniform civil code. But not the citizens can go to the court and ask that every state government should have an uniform civil code, because it's only what type of obligation upon the state. It is only a moral obligation. So they cannot enforce these provisions in a court of law. Is that clear? That is what is understanding you should have. Is that clear? Okay. All right. So what is the next thing? So we'll go to the next thing. So write down the next topic. Secular state. Okay, secular state. So write down a line as to what is a secular state. Secular means the state is non-religious in character. Secular means the state is non-religious in character. So what do you understand by the word non-religious in character? Not only not favoring any religion. When I say not favoring any religion, that they do not discriminate between religion. But non-religious means something little different. That means the state does not identify itself with any religion. The state has no official religion. Is that clear to all of you? The state does not have any religion. Neither it identifies itself with any religion, nor it favors any particular religion. It is not simply non-religious. That doesn't mean the state is against religion. No. Because there are few states which may identify itself with some particular religion. Say, for example, there are few states which are against religion. But when I say non-religion, we are neither irreligious or we are anti-religious. But you're only non-religious in the sense the state has nothing to do with the religion. Religion is purely the affair of whom? Religion is purely the affair of the citizens, whatever, or the individuals in that particular state. Whatever religion they want to identify, they can identify with a particular faith or religion. They can have their own religion. But as a state, I'll equally protect all the religion. As a state, I'm not going to discriminate between the various religion in our country. So when I say state is secular, it means the state is non-religious. Further write down, the state does not discriminate. The state does not, so okay, before that, the state is non-religious. The state does not identify. The state does not identify with any particular religion. The state does not identify itself with any particular religion, or it discriminates, people on the basis of religion. Or it discriminates people on the basis of religion. Or it discriminates people on the basis of religion. That's basically what is called as secularism. So right now you have a very basic understanding. But however, how many of you also heard? I think some of you might also know this. I'm not sure if everybody knows this. Somebody might have heard that though India is a secular state, the kind of secularism or the model that we follow in India is slightly different from that of the Western countries. In Western countries, usually the concept of secularism is what is called as negative secularism. Whereas in India, the concept of secularism is what is called as positive secularism. So largely in both the countries, secularism as an idea is the same thing. But the way we practice is a little different from that of the Western countries. So for time being, I'm not getting into that because I'll have to make a discussion of that, the positive negative secularism, when I do the preamble to the Constitution of India. But however, largely I'm trying to restrict the definition of what is called as secularism. So what do you understand by secularism? Secularism means normally the state is non-religious. The state does not identify itself with any religion, and the state neither discriminates people on the basis of religion nor it identifies itself with any religion. Just write down one more line to that. Though the Constitution of India, though the Constitution of India provides for a secular state, though the Constitution of India provides for a secular state, the kind of secularism that we follow, the kind of secularism that we follow is different from that of the Western secularism. 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 Western secularism. In West, they follow negative secularism. In West, they follow negative secularism. Whereas in India, in West, they follow negative secularism. Whereas in India, we follow positive secularism. In West, they follow negative secularism. In West, they follow negative secularism. Whereas in India, we follow positive secularism. So therefore, what is the basic difference between a negative and a positive secularism? There are a few differences that I can bring in, but what's the basic difference between a negative and a positive secularism? The most important difference between the negative and positive secularism is they follow what is called a complete separation model. So complete separation, I'll explain what is this complete separation. Here there is no complete separation. When I say complete separation, don't confuse that with the separation of powers, but rather here it is a complete separation and no complete separation between what? Between the state and religion. So complete separation between state and religion. So here there is no complete separation between state and religion. What does it mean when I say there is a complete separation between state and religion? In the Western countries, they also believe in the same idea. The state is non-religious in character. They do not identify with any religion, nor they discriminate people on the basis of religion. But also what they follow is that in the Western countries, religion is a purely a private affair. So for example, if a religious institution is there, suppose let us assume a church is there, any of the other religious institution is there in a Western country. When I say Western country, most of the European countries as well as United States of America, that is what I call as West. If any church is there in these Western countries, the state has nothing to do with what kind of practices they follow in the church. If the church is taking a decision to exterminate some of the people, that means, do you know what do you mean by exterminating some of the people? Exterminating means a religious order can be issued by a religious authority that some of the people shall not enter the church. The state has nothing to do with this. It is purely a private affair, purely between the church and the citizens. The state does not involve in these things. Is that clear to all of you? The state completely separates itself from the religion. But do you think that in India the state completely separates itself from the religion? We do not clearly separate from the religion because we follow what is called as an interventionist model. Or I would say that the Constitution of India allows a positive interventionist model. Can the state intervene in the matters of religion? Can you give an example of some positive intervention? So when I say positive intervention, that the state can intervene in the matters of religion. Why the state can intervene in the matters of religion? It's not only about Shabrimala. Shabrimala is definitely a good example where the state has intervened and it has allowed the women to enter into the temple in certain age group, the age of 10 to 50 years. A state has intervened in a number of areas which I can give, but I wanted to give a very simple example. I'm not going to any case law. So, for example, if let us assume the state in India also following a negative secularism as that of the Western countries. First, let me get into the basis behind as to why this model is followed. Then I'll give an example. Now, if you see for any country, the way the secularism that they follow is based on their history. So things we'll have to go back and try to understand from historical point of view. So in the Western countries, they have evolved as a negative secularism basically during the medieval time when the nation states started forming. After the medieval time, in the Western countries, there was always a conflict between the authority of the king and the authority of the church. Therefore, to put an end to the conflict between these two things, they followed what is called as negative secularism. Let the king take care of the administration and of the country, the church will take care of the religious matters. You do not intervene in my matter, I will not intervene in your matter. So that is how they continuously followed over a period of time. Even during the modern time, they kept following what is called as complete separationist model, or the religion is completely separate from that of the state institution. But whereas in India, we never had a king like that. We are already ruled by the Britishers. But the biggest problem for India when India became independent is, unlike the Western countries, in India we had what type of population? India was largely having a heterogeneous population, but rather they had a homogeneous population. Largely everybody belonged to one particular religion. Is that the factor in India? India had a very heterogeneous population, different caste, different religion, and our biggest problem is not only interreligious conflict. There are also what is called as intra-religious issues. Of course, there are issues between different religion, minorities and majorities in terms of religion. But the issue was also what is called as intra-religious. Within religion also there were discriminatory practices where as a religious practice it was accepted. So can you give me intra-religious practices? The practice of untouchability within the religion, within Hindu religion. Say for example, within the Hindu religion, again you can say not only the practice of untouchability but also gender injustice. Women were not given the rights, male were given the rights. All these things were accepted in the name of religion. In fact, untouchability is an accepted practice in Hindu religion. Therefore, for the state like India, if the state is to act as a mute spectator to the religious practice, will untouchability continue to exist even today? Because the religion has accepted for it. The religion has accepted for what is called as gender injustice. So widows were not allowed to remarry, widows were burned, for example. The religious practices accepted for this. So in case of India, do you think that the state can be a mute spectator to the religious practices, or they have to make some intervention wherever it is required? So wherever it is required, they have to make an intervention. Because many of the religious practices were found to be violative of some of the fundamental rights even. So for example, religion allowed for untouchability, but abolition of untouchability is a fundamental right. And not only the fundamental right, it violated various other rights. Say for example, if women are not allowed to remarry, women are not allowed to exercise right, it also affected the right to life and liberty under Article 21. So the state cannot be a mute spectator to the various religious practices. Therefore, what kind of model India has to follow? India has to selectively intervene wherever it has to intervene. Therefore, we followed the model of what is called as positive interventionist model. So the basic difference is, here there is no intervention, here there is a positive intervention. So this is the basic difference between what is called as negative secularism and positive secularism. So please take down a question on this, a 10 marker question, 150 words you can write. So take down a question. What do you understand by what do you understand by the concept of secularism? What do you understand by the concept of secularism? What do you understand by the concept of secularism? Differentiate between. What do you understand by the concept of secularism? Differentiate between positive and differentiate between negative. Okay, differentiate between Indian and Western secularism. Differentiate between Indian and Western secularism with suitable examples. So you can write it either in point format, or you can initially start defining what is secularism, then you can bring in tables and give examples. It is up to you. Okay, so you just start writing. Over a period of time you will get an idea as to how to do this. So whatever questions that I give, some of these questions we will discuss during one later class. There is a class where I'll discuss all those things. Okay, but however, as I already said, you try to first write it on your own so that you get a fair idea. All right, so please come to the next thing, that is universal adult suffrage. 10 marker. Universal adult suffrage, or you can also call it as universal adult franchise. Suffrage or franchise basically means rights. So write down a line. The Constitution of India allows, or the Constitution of India provides, the Constitution of India provides for universal adult franchise. The Constitution of India provides for universal adult franchise. That is every eligible adult individual, every eligible adult individual, every eligible adult individual shall have the right to vote. Every adult individual shall have the right to vote, subject to subject to subject to regulations, subject to regulations, subject to regulations that can be made by a law. Subject to regulations that can be made by a law. That means though every adult individual shall have the right to vote, further who can exclude some of the adult individuals? The law can provide for certain criteria. Is that clear? So subject to that, every adult individual shall have the right to vote. Come to the next thing, that is single citizenship. Single citizenship. Single citizenship. The Constitution of India, the Constitution of India provides for only one identity. The Constitution of India provides for only one identity, to all its citizens. The Constitution of India provides for only one identity to all its citizens. That is only the national identity. That is only the national identity by providing for a single citizenship. But by providing for a single citizenship. By providing for a single citizenship, unlike unlike some of unlike some of the other federal constitutions, unlike some of the other federal constitutions which provide for which provides for unlike some of the other federal constitutions which provides for both national as well as regional identities. Which provides for both national as well as regional identities. For example, how many of you know that in USA there are dual citizenship? There can be citizenship for the entire country, and there can be citizenship for every state as well. USA is also a federal political system. India is also a federal political system. But however, in India, there's only one identity. What is the only identity that we have got? Citizen of being our country. That is Indian citizenship. There's no citizenship for any state. In fact, the Constituent Assembly members were very clear, giving them dual identity, which identity will have a profound effect upon the individual. Regional identity or the national identity. First, what will come is our regional identity, probably because of the cultural distinctions and all those things we have got. And they thought that that can go against the very idea of what is called as fraternity, common brotherhood. So therefore, they thought only one identity, and that identity is that citizen of the country, that is Indian citizenship. Is it clear to all of you? So write down the next thing, that is independent bodies. Independent bodies. Independent bodies means independent bodies means bodies which are largely independent. Bodies or institutions. Basically, bodies means institutions. Bodies or institutions which are largely independent in terms of their functioning. In terms of their functioning. In terms of their functioning. Powers. 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 And they have a very significant position. And they have a very significant position under the Indian constitutional system. Under the Indian constitutional system. Under the Indian constitutional system. That means you can try to understand there are many institutions in our country. For example, think in this way, there are many institutions in our country that they are given a lot of powers under the constitution. They are supposed to perform a very important function under the constitution. They directly derive the powers from the constitution. So can you just think of such institutions? See, majorly we have seen under the concept of separation of powers, there are three important organs. What are the important organs? Legislature, executive, and judiciary. But the country cannot just function with only these three organs. Of course, they have a very important role to play. But apart from this, a lot of other independent bodies, which the constitution itself may provide for. And they have a very specific function to perform. Such bodies are largely what is called as independent bodies. It doesn't mean that the judiciary cannot question them when they do something unconstitutional. But largely, their powers are given by the constitution itself. Can you give me examples of such independent bodies? Very good. The Public Service Commission. So you can write down examples. Examples include the Comptroller and Auditor General, CAG, CAG. How many of you heard about the CAG? Comptroller and Auditor General. Can anyone tell me the CAG comes under which ministry in the government of India? Which minister is in charge of the CAG? Which minister? Just think. I think you may get the answer. Finance. Okay, then any other ministry? Finance Ministry is not the answer. Any other ministry? Ministry of Home Affairs? No, not the answer. Which minister? Any other minister that you can think of? The answer is no minister. As I already said, it is an independent body. It does not come under the control of the government. That is why it is an independent body. Is it clear to all of you? So the answer is what? It does not come under any of the minister. It's a largely an independent body. What do you think that the CAG has to do? The CAG has to audit the government accounts. If any minister is in charge of the government accounts, if this CAG, how they will be able to perform their function effectively? So the CAG is largely an independent body under the constitution. Is it clear to all of you? It does not come under any of the ministry. Similarly, Election Commission of India. So Election Commission of India comes under which ministry? It does not come under any ministry. It is an independent body. The Election Commission of India. They have to perform a free and fair election. They cannot support any government or any minister. No, it's an independent body. Similarly, Union Public Service Commission. The Union Public Service Commission has an important role to play. What is the role that they have to play? They have to recruit. There are important recruiting agency of the government. Largely they function but independently. They have to recruit the best brains of the country probably, and they have to recommend appointment to the government of India. Suppose if they are not independent, then they can only select the sons and daughters, granddaughters of the ministers, big politicians, and some existing bureaucrats. Then what will happen to the common people like us? You may not have interest and faith in preparing for this examination, because how many years you have to spend? Probably you are also taking a big risk by preparing for this. But what is that allows you to take that particular risk? Because you know that it is going to be largely a free and fair recruitment process. You have an equal opportunity in being successful in this examination. Is that clear? So it's an independent body. That's the way that it functions. So CAG is there, Election Commission of India is there, Union Public Service Commission is there. So these are all examples of what is called as independent bodies under the constitution. Yes. Which one? Raw is under the control of the government. It is not an independent body. It's one of the direct control of the government. Okay, so it's not an independent body. In fact, the raw directly comes under the cabinet secretary and the prime minister. So it is directly under, raw cannot function independently. It does the intelligence function for the government. They cannot function on their own. That is not possible. Niti Aayog is not an independent body. Niti Aayog is a think tank for the government. It's not an independent body. All right. SSC, they are not protected by the constitution. SSC is a staff selection commission, but they recruit for some lower authorities. They are not as independent, or the powers is given to such a body under the constitution. So it is, I won't say it is an independent body. It may have the influence of the government still, but still the SSCs are bodies which are established by some laws and all those things. Still, they may have some element of protection by the law, but their stature is not as high as that of what is called as Union Public Service Commission, which is directly protected by the constitution. So we cannot have thousand institutions. You cannot ask me a query and we will can explain. We don't have the time. But what we will understand is largely over a period of time, you itself will analyze that which is an independent body, which is not an independent body, as we will proceed through the constitution. Right on the next thing, that is emergency provisions. So this is again a very, very important provision in the constitution. Just write down couple of lines, then we'll discuss further on that. Write down, these are extraordinary provisions in the constitution. These are extraordinary provisions in the constitution. These are extraordinary provisions in the constitution. These are extraordinary provisions in the constitution which allows the constitution to go for a transformation, which allows the constitution to go for a transformation under certain extraordinary circumstances, which allows the constitution to go for a transformation under certain extraordinary circumstances, which allows under certain extraordinary circumstances like war, external aggression, armed rebellion, constitutional breakdown in a state, constitutional breakdown in a state, comma, when the financial stability, when the financial stability, when the financial stability and the credit of India is under threat. When the financial stability and the credit of India is under threat. When the financial stability and the credit of India is under threat. So I'm just repeating it again. What is the emergency provisions? These are extraordinary provisions in the constitution which allows the constitution to go for a transformation under certain extraordinary cases. When these cases arises, say for example, when India is at a war, when India is facing an external aggressor. Who is an external aggressor? An external aggressor. War means always it is two-sided. So officially both the sides are engaging each other. But an external aggression means unilaterally somebody is acting as an aggressor against our country. There's a unilateral aggression by one country where India is just maybe we are defending it, but we are not engaging in war. But after some time, we may also go for a war. But before that, it can be an external aggression or a war or an armed rebellion. What do you mean by an armed rebellion? Armed rebellion is usually internal in nature. Can you give me an example of armed rebellion? Very good. The Naxalite or the Maoist movement could be an armed rebellion, which is not a major threat to our country right now. The kind of might of the state can easily suppress that. But suppose if it is threatening our country, that can also be a ground to go for emergency. It can be war, external aggression, armed rebellion, or there's a constitutional breakdown in a particular state. So when I say constitutional breakdown in a particular state, suppose let us assume in a particular state, not in the entire country, in a particular state, a particular government is not having majority. Now, under such a circumstances, what kind of rule will be imposed in that particular state? President rule. I already told that. So on that particular ground, or it can be what is called as that the financial stability and credit of India is under threat. Suppose for a reason because of geopolitics, suppose let us assume the oil prices doubles or triples, it may lead to what is called as a financial emergency, because anyways for oil, in what we have to pay? We have to pay it in Indian rupees or we have to pay it in dollars. And the more the dollars we pay, more the dollar reserve is less, and all the imports has to be paid on dollars. That is going to have a serious financial consequence for our country. Under such a circumstances, we can also go for what is called as an emergency. Now, depending upon the nature of threat, different emergency can be brought in. So, for example, for a war, external aggression, armed rebellion, national emergency can be brought in. When there's a constitutional breakdown in a particular state, a state emergency or the president rule can be brought in. When there's a financial threat, financial emergency can be brought in. So, depending upon the nature of threat, there are different emergency that can be brought in. But however, one thing that you have to understand is whatever may be the emergency, the constitution goes for a transformation automatically. Without changing anything in the constitution automatically transforms itself. And what kind of transformation it shows? Which is otherwise a federal political system. Normally, what type of political system are we? Federal political system. And what is the basis of a federal political system? Division of powers between the center and the state, which is otherwise a federal political system. When there is any emergency provision invoked, automatically the constitution transforms itself more like a unitary political system and not like a federal political system. So what is the very essence of a federal political system? The very essence of a federal political system is that there is division of power between the center and the state, which means the states are not subordinate to the center. But when any of these emergency provisions are invoked, the constitution, there is no change in the constitution per se, but automatically the constitution transforms more like what type of political system? Unitary political system. That means more powers will be concentrated in the hands of whom? In the union executive and the union legislature. Automatically the states may be deprived, relatively, not completely, relatively they may be deprived of their powers. So these are all extraordinary features whenever there's a need for an emergency. So you can just make a brief note of this. When it comes to emergency, we'll discuss these things later in detail, but right now you can have a very brief idea about all those things. So there are three types of emergencies. What are the types of emergencies? National, state, or you can also call that as president rule, and also what is called as financial emergency. National emergency, state emergency, or president rule, or financial emergency. And these three types of emergencies can be imposed on different grounds and different articles. So first we'll see the article, relevant article. Under what article do you know that the national emergency is imposed? Under Article 352 of the Constitution, Article 356 of the Constitution, Article 360 of the Constitution. And what is the ground on which these emergencies can be imposed? If there is a war, external aggression, or armed rebellion. In all these cases, you can go for what is called as national emergency. There's a constitutional breakdown in a state. Threat to financial stability and credit of India. Threat to financial stability and the credit of India, there can be what is called as the financial emergency. So these are all the grounds. We'll deal with this in detail. In fact, for the emergency, we need to have a discussion for 3 hours. Then only it will be very clear, but we'll do it at the later stages. But for time being, what is the only thing that you have to understand, that what kind of transformation the constitution goes for when there is any of these emergency provisions. How the constitution transforms? It transforms itself from what type of political system to what type of political system? From a federal political system to a unitary political system. But the transformation can be relatively different. The highest degree of transformation is in which type of emergency? National emergency. Then the second, relatively less but more, is in what is called as state emergency or the president rule. Relatively, it is less in terms of what is called as financial emergency. Now, for all these three types of emergencies, do you know which emergency power has been invoked the most? Which emergency has been invoked the most? Which is the least? Or in other words, you can say that the financial emergency has never been invoked. Financial emergency provision is never used in our country so far. In 1990s, the government was almost on the verge of going for a financial emergency, but somehow they avoided it. But which is the most which was invoked? State or national emergency? How many times the national emergency? 3 times. So the national emergency so far has been 3 times, but you know how many times the state emergency has been invoked? More than 125 times. I think approximately, I think recent reports say it is almost around 140 times. A little more than 140 times probably. That means it is a state emergency which has been invoked the most times. Is there any state in our country where it has not been subjected to the state emergency? Telangana and Chhattisgarh, very good. Relatively new states. Even in these states, in Chhattisgarh, somehow the government tried, but they could not do it. But however, in most of the states, the president rule has already been imposed. But how many times and all those things is not important for you. But you'll have to just understand whenever there's an emergency, what is likely to happen, the constitution will go for a transformation. To what extent they'll transfer, what are the provisions, we'll learn all those things at the later stages. So these are all some of the important things that probably you should have an idea even before we get into the subject. All right. So just have a look. I think this question we already done it. So please go through your notes very quickly. Uh, and then if you have any questions, please ask me.